So the next session is featuring a brand new tool from NICE that actually has been adopted by the police sub-team of my advisory committee. And it's a tool that's actually from Hamilton and Halton, tweaked by people from Ottawa and Toronto. And you'll notice that on the back it says that it's a piloting edition. So we're actually just sort of trying this out on you to see what you think, which is a step that we go through on all of the tools on our project. So I'd like to introduce to you our next speaker, who is Christina Wolf. She's a sworn officer with the Ottawa Police Service, and she has been for 20 years. She started when she was 2. Isn't that when you said you signed up, yeah. Bernie? Yeah. So anyways, she currently holds the title of Acting Sergeant and has worked in the District Investigations and in Criminal Investigations Division of the Ottawa Police from 1999 to 2010 or 11, ongoing. In 2005, she was selected to head the new Ottawa Police Service Elder Abuse Section, which was launched in January of that year. And while in the Elder Abuse Section, Christina was a member of the Clinical Consultation Team, a multidisciplinary subcommittee of the Council on Aging Elder Abuse Steering Committee in Ottawa. She was also a member and leader for a while of LEAPS, which is the Law Enforcement Agencies Protecting Seniors in Ontario, a provincial network of police concerned about abuse of older adults. And she remains a member of the Elder Abuse Theme Team, my advisory committee, and leads the police sub-team. And that team has played an instrumental role in taking both this tool and the Elder Abuse Assessment and Intervention Guide and bringing it up to sort of our current state of knowledge in terms of police intervention in this field. In May of 2009, Christina was also nominated for the Ontario Women in Law Enforcement Excellence in Policing Award. And she's a mom, and she's a policewoman, and she's got to get their kids to hockey and baseball and all that. So without any further ado, please welcome Sergeant Christina Wolf.
Yeah, okay, terrific. Hi. We're, I guess, switching gears a little bit. I was a little intimidated listening to all the academic stuff. I'm like the frontline worker bee, and this is very practical stuff. It's a user-friendly tool, I'm hoping, for frontline. And I was just kind of hoping to maybe canvass the room and see how many people actually do work on the front line in whatever capacity. So, okay, getting a relatively good show of hands. So it's not all think tank people in here. There's actual people on the front lines. Okay, good. So you can relate to me. This is a police tool, but, it's equally important for other people who are actually working on the front line and might be in a position to detect financial abuse to be aware of this as well, because it's not exclusive to police, actually. It's quite handy, I'd say, even for family who are trying to advocate and maybe direct an older person in their within their family setting. So basically what will be covered here is how police investigate these types of crimes and how much we rely on other people in the community to actually do that as effectively as we can, because the bottom line is that you're largely our eyes and our ears. We hear about stuff after the fact. It's very seldom that the older adult actually comes to us to complain. So, and I don't think that that's a surprising thing to be saying. That's essentially what we're dealing with in my neck of the woods. So, we've covered some of this stuff already, right? We're rhyming off statistics to kind of project where we're going to be in, a decade, 2 decades, whichever. Some interesting or other staggering statistics is seniors account for 70% of our nation's wealth, that being North America. Another alarming thing that I'd learned of was, according to a 1997 Gallup poll, Canadian baby boomers were expected to inherit an estimated $1 trillion in bequests over the next 20 years. And given the date of that poll, we can safely assume we're more than halfway through that. Information from the same poll estimates that between 8 and 10 million bequests are expected as a result of the record accumulation of wealth in Canada since World War II. And you couple this with the fact that we're in an age when we've accumulated more debt than ever before, this can quite likely amount to a recipe for disaster. And, it's that whole thing about, I think Ken was talking about the entitlement thing, where you've got an older generation of people who've lived through wars, they've lived through disasters, markets crashing, and they've spent very conservatively, they've lived within their means to be careful, and they've given birth to generations of spenders, and we're living well beyond our means, and there's box stores being thrown up on every corner, within a kilometer of each other. It boggles my mind how everybody stays alive in the entrepreneurial world, but we're spenders. I mean, my 9-year-old is a consumer. He goes online and he shops for the next baseball hat he wants. It's kind of sad in a way, kind of ridiculous, but that's essentially where we're at. And then again, as was mentioned earlier in another presentation, is people are living a lot longer than they ever have. Life expectancy isn't what it once was, and when you live into your twilight years, you require care. You require assistive devices. Retirement homes are astronomically priced. Nursing care is very expensive. And so you need your nest egg to live off of, to draw off of, to live comfortably. And then someone comes along and there's that entitlement thing. That's going to be mine one day anyway. I'm going to inherit it. No one's going to spend it. I'm going to take a little bit now. If mom or dad has dementia, they won't even notice. Even if they do, they'll forgive me because I'm their son or daughter, and, there's this unconditional love thing going on, all these dynamics that we're playing with when this situation comes to us. So we get this great big ball of wax, and, we're peeling away layers trying to understand how this all happened. So anyway, put that aside. You'll notice that if you try to follow along on the slides, in the interest of trying to condense this as much as possible, I've eliminated some things. So we'll just kind of barrel ahead. So where am I? Okay, so yes, I guess, the police work with a Bible called the Criminal Code. That's our go-to. That's our source to kind of tell us what authority we have and what kind of situation we might be dealing with. So this is basically it's not an exhaustive list, but it's a lot of charges that we have contemplated or actually laid when we're dealing with a theft by power of attorney or a similar type of situation. So it's not in the tool itself. I'm going to have everybody has one of these, I hope, because we'll kind of read along a little bit in a while. So in keeping with that, these are the charges that we contemplate. Now, I want to just say for the record, too, though, that we did compile our own statistics from a layman kind of way, and 10% of the investigations that had been assigned to our section in the 6 years that I was there actually resulted in a charge being laid, in an arrest being made. So that said, what we're doing largely is social work as police. We're not the arrest authority. I mean, we are, but we're social workers with arrest authority is in essence how we do our work within the framework of policing. And it's necessary. It has to be when we're dealing with this kind of phenomenon. So some of the charges here, stopping the mail with intent. It's pretty amazing how far someone can wield their newfound authority. You get a power of attorney paper and you just wave it in everybody's face. And it's amazing how many people just sort of relent, or not even relent. They just look at it at like it's legitimate and don't ask any questions. And that's really unfortunate with banks. We've found. Are there a lot of people here from the banks? Can I get a show of hands? About 5? That's a record. There's 7 people here from the banks. Did some people sneak away? There's only 5. I only saw 5 hands. Anyway, that can be really problematic too. But I think I'll get into that in a little bit of. Hang on a second here. I've got to follow my script. Yeah, it's the bad guy. When the bad guy, and this is police terminology. So when the bad guy gets hold of a power of attorney document, naturally, what we've discovered in our work is the first place they go to is the bank, because that's where the money's at, right? Show me the money. That's what's motivating them to get this power of attorney document and misuse it, is because they want to access money. So they run to the bank, and the bank honors this power of attorney. But the problem is that the good folks who catch wind of it after the fact, and even in some cases the police, they emerge onto the scene after the fact, and the banks are not believing, like they really still want to honor that first bit that happened, and so they tend to perpetuate the problem and kind of make it more difficult for us to intervene. And it's because they're so fearful of admitting that maybe they've done something wrong, because there's no really coming back from that. So this is something that we've experienced, and it's like a sad irony, because in an effort to try to be free of any kind of liability, they're actually sticking their necks out, and that they might actually get burnt. So it's just kind of something interesting that we've observed. So theft by power of attorney is actually very common. 70% of our work is financial abuse, and because we're dealing with that, dependency, that there's an existing relationship of trust or dependence between the victim and the person that's abusing them, the theft by power of attorney piece is actually quite prevalent. And so, there's different types of powers of attorney. And this is the thing, too. This was born out of Ontario, and it originally looked like this. This was a two-sided laminated 8 by 11. And it was pretty exclusive to Ontario provincial legislation around substitute decisions and that kind of, those kinds of pieces of legislation. And we've had to modify it so that it actually is something that's user-friendly or valid across all the provinces and territories in the country. So this education piece, or this PowerPoint that marries up with it, is essentially just kind of pointing out that there's all different kinds of powers of attorney documents. It does change from one jurisdiction to the next, and so we're dealing with durable ones, non-durable ones. In Ontario, it's a continuing power of attorney, and at the bottom line is, whatever way you want to word it, Section 334 of the Criminal Code speaks to its misuse in the vein of the substantive charge being a theft, because the bottom line in the police world is it's a theft. There is no actual, what's the word I'm looking for? There's no sentencing that's attached to a theft by power of attorney, as Section 331 of the code. It's a theft. So we would lay a substantive charge of theft, and then to maybe elaborate or articulate further what the issue was around the theft for the Crown's purpose, who's going to go forward with our charge, is we'll put in the wording of what of the theft by power of attorney within the criminal code. So let me just see. Okay. The other issue too is that it's possible to have more than one power of attorney in existence at the same time, which can can create a lot of friction. And we've seen that as well. You've got somebody in Ontario, and especially in Ottawa, because you just hop over the bridge and you're in Quebec. So you've got a power of attorney existing in Ottawa, and then you've got another piece of legislation. I can't even. It's not a power of attorney document. It's a curator. Yeah. What is it? A mandate. Okay, the procuration or something like that. Yeah. So you have somebody who's maybe managing a bank account in Ottawa, and then somebody's managing a piece of property in Quebec. And so, the person who's got charge of the property wants to make some upgrades. They need to put in a ramp for a wheelchair or what have you, and they need to get money from the bank account in order to do that, but the person who's in charge of the bank account doesn't agree with the renovations. It can be a potential nightmare, just trying to have these two pieces of paper intersect so everybody can agree. It can be quite problematic. And then the bank power of attorney issue is also, potentially a thorn in our side. And again, ironically, the bank sees, Junior and Mom come in, and they're asking for money, and the bank thinks, well, we're going to do our due diligence, and we're going to get a power of attorney signed right here, a bank power of attorney, but without the bank power of attorney exclusively being worded to speak only to that account, it's going to negate or it's going to revoke all pre-existing power of attorney documents that are out there. So if bad guy is in the bank and now they've drafted this power of attorney document and not specified this is only for this account, it can potentially, revoke. Well, it depends on, not in BC? Is that right? Okay. Well, and it can be very contentious, and it results in a lot of litigation in my jurisdiction. And it's all a matter of semantics. It's all a matter of how something is worded in one document versus another. So it can be potentially very problematic. So moving along, some pitfalls that we've observed is obviously without some kind of a triggering clause or a springing mechanism, the power of attorney can be acted upon immediately. Now, does that exist here with a power of attorney for property?
That'll be clearer as of September 1st.
Yeah, the legislation's changing.
Mm-hmm. Okay. Changing in what sense? In that?
It's clear. It's in the legislation that you can make the springing clause, like how to trigger it all out.
And but the document itself, is there going to be like a caveat that's built into the document that protects that donor? There will be? Yeah, the person who, like the older adult who's giving power of attorney to someone, is there going to be some kind of mechanism built into the document that says under what circumstances and when and by whom the power of attorney will come into effect? Okay, because in Ontario, well, then you're leaps and bounds ahead of us, because in Ontario that's not the case. In fact, this is what ours, I don't think that'll work, but no. Go back. I highlighted this part. I don't know why it's, I've tried to make it bigger, but unfortunately I'm not a techie. So, but basically in our continuing power of attorney for property, just for property, the fifth item that speaks to conditions and restrictions actually says attach, sign, and date additional pages if required, but then in brackets it says this part may be left blank, which is hugely contentious, because you picture bad guy sitting at the kitchen table with mom or grandma and saying, look here, grandma, it says you can leave it blank. We'll just leave it blank. But without actually saying, expressly when it can be used or how it can be used, it's automatically, like before the ink even dries, somebody can be walking out of that kitchen with, two witnesses in tow, equally questionable, and off they go. And then yours is like that?
Yeah, you can put the restriction in, but the standard form will be signed and it's done.
Okay, but you're saying, though, before that there's some kind of protective measure there, though, that's going to... Okay. Okay, right. That's the problem, though, if you write it in. So if you don't write it in, and, maybe this is very negligent. I mean, to say that this area may be left blank, please tell me yours isn't going to say that. Because that's ridiculous. I mean, that's just carte blanche. What's that?
We don't even have a reminder that there's conditions and restrictions. It's just the standard form.
And that's why the education piece is so critical. Seniors need to know that this has so much power. Like, you're giving so much power to somebody. You need to know what you're doing. You need to know to list under what circumstances you're allowing this person to take charge of just about everything. So that's a huge pitfall. The other issue, too, is you can download these forms off the internet, right? So again, it's not a matter of going into a lawyer's office. It's a matter of printing it off and sitting someone down at the table or wherever and cajoling them enough to sign off, and there's no witnesses other than frickin' frack who are in tow, and just they have the same, like, I get my share if I sign here, right? That sort of thing. So, and then nobody else knows about it, right, until the damage is done. So that's a huge issue. There's no registry, right? There's no mechanism by which you were able to monitor that they exist. We've got birth certificates, we've got death certificates, we've got marriage licenses. We have, bodies, regulatory bodies that hold these documents that you can go, you can make inquiries, you can get this information. However, I get that. You're born once, you die once. It's easy to keep those documents somewhere. Power of attorney can change every week. It can change every day. We've seen those things where it's just like it's a serious case of tennis. Like, it's just bouncing it back and forth. So that would be hard to have some kind of registrar that keeps, having these things pour in. It'd just be a nightmare, I'm sure, to deal with. But it's a nightmare not having some place to go to get these documents. The other thing, too, is the power of attorney document enables that attorney to do anything and everything except make a will. Except that. And I put to you this, that anybody who's been able to finagle their way in that deep to get power of attorney is also able to use whatever influence they need to, manipulate and change a will. I mean, I've seen that too. So, okay. Sorry, that was all this stuff. Okay, so moving ahead. So the advice that we're able to give when we do our education pieces is, get the power of attorney drafted within a law office, right? With the assistance of a solicitor. At the very least, have it notarized. Use the restrictions and conditions portion of the document to protect yourself. Consider a joint power of attorney, which obviously is going to increase the accountability. It's going to minimize the temptation to do something nefarious with your authority. And again, like not, somebody was saying the daughter and the unlikable son-in-law, because they could be in cahoots, but maybe rather having a daughter and maybe a best friend. Somebody, two people in different areas of your life that equally or should equally have your best interests at heart, but who will have to, check in with each other. So it just basically puts some checks and balances there that, people need to check in before they take any action. And to leave your documents with the solicitor. And this is something that they have done in the Waterloo region. And there was only actually one law office in particular that we applaud for doing this. But it's basically drafting the power of attorney documents in the law office and leaving them there. But in lieu of taking out those documents with you, to have an actual letter that's drafted that acknowledges that one was done, where it can be found. And so if anybody has inquiries that they want to make towards that document, or they want to access that document, again, there's a checkpoint. There's some place they have to go to, and they know where to go. And with the senior who may, mentally decompensate over time, they've got that letter. They've got that for safekeeping to remember to know where that document is. So again, it removes that temptation, because just waving this thing, it's incredible how much damage can be done. And the most critical piece is that they can revoke the power of attorney. A lot of our victims that have come in have just been completely frazzled. I mean, I had one guy who was suicidal because he didn't know how to make it all stop. And when he was told, you can revoke this just as easily as you invoked or created one, just basically invoking it, then like it was just like this weight of the world lifted off of him. So it's another piece that's very important for seniors to know about that sadly they don't. It just astounds me. Okay, so going into the theft by person holding power of attorney. So in the tool itself, it gives you word for word, verbatim, out of the criminal code, what a theft by power of attorney is. I'm going to read it just to humor you. It says, everyone commits theft who, being entrusted, whether solely or jointly with another person, with a power of attorney for sale, mortgage, pledge, or other disposition of real or personal property, fraudulently sells, mortgages, pledges, or otherwise disposes of the property or any part of it, or fraudulently converts the proceeds of a sale, mortgage, pledge, or other disposition of the property or any part of the proceeds to a purpose other than that for which he was entrusted by the power of attorney. Did you get all that? It's a mouthful. The law can be so wordy, but it's written in such a way as I think to encompass as many possibilities as one could anticipate. But in a nutshell, and for the purposes of describing the bulk of police investigations into this type of crime, it's basically this. It's a person who has a legal power of attorney document that appoints or authorizes them to make financial decisions for someone else, and they misuse it. They misuse that authority for their own personal gain. That's, in a nutshell, what we're dealing with in a theft by power of attorney, and that's what this tool is, has been created to assist officers in taking next steps to eradicate, to educate the victim. So, the key questions in the next portion of the tool are, is there evidence of money or property missing? And does the offender have power of attorney? for property. And if the answer is yes to both, then the next question obviously is, well, what is the cognition? What is the capacity of that victim? And now the important thing to remember, too, is that there's a presumption in law that one is capable until deemed otherwise. Now, this is common law. There's case law that supports that. I know within Ontario, the Substitute Decisions Act, Section 2 also points that out more clearly, more tangibly. But this, again, is information that was endorsed. I'm not a lawyer, but this is information that was endorsed by the Advocacy Center for the Elderly, as well as the legal staff at our Public Guardian and Trustee's office. So we go on this presumption of law quite heavily, and it can be quite... It can ride in our favor from an investigative standpoint, and it's also for the benefit of the older person in many cases, right? So I'll give you, for instance, I had a predatory marriage. I had an 89-year-old man who was married to a 39-year-old woman who was, I'll say again, a very enthusiastic crack cocaine user. And she was in a relationship, go figure, with another crackhead who was living with them. And this little old man was stuffed in a room at the back of the house. And when they had this big blow up, the two crackheads that is, and the police were called in by neighbors, she was kicking the boyfriend out, and the boyfriend, being in a rather vindictive mood at the time, decided to, divulge to the police that there was a little 89-year-old man in the back of the house. And so this is sort of how I kind of parachute into the situation, and I'm looking at this poor man. He's blind, and he has no stimulation whatsoever in the room. There's no TV, there's no radio, there's no telephone, there's no books. Clearly, he's an avid smoker. You could cut the air in the room with a knife, pretty much. Sealed shut window, tiny room. And I asked him, "How you doing here?" "Oh, I'm fine." Okay, but I'm noticing, unkempt, filthy, emaciated, dehydrated, dirty man, just really, really not kept, not cared for. And he wouldn't complain about anything. Because he has dementia? Yeah, there's a possibility that, there's a whole bunch of reasons, right? Like, if you take me from here, where are you going to put me? Maybe, better the devil I know than you kind of uprooting me and putting me in a home somewhere. So a number of reasons why maybe he didn't want to come forward. But you know what? I was able to take him and bring him to hospital on a social admission to force the hospital, to force healthcare to deal with the situation, because we didn't really know what we had at the time, but clearly I couldn't leave him there. And while there, we were able to do a number of things, such as, because he's presumed that he's well, right? He's presumed capable until proven otherwise. And so I made haste to change a few things. And by that I mean I picked up the phone while there with him at hospital, and I called his bank and made them aware of what was going on, and suggested that they open a bank account that was exclusively in his name, because everything was joint with his wife. And so they did that. They were very much amenable to opening an account exclusively in his name. The next step was to contact all the pension sources. This man was excise tax director for the federal government who had a very healthy pension, and it was a matter of calling superannuation and the other pension sources and saying, you know what, we need you to redirect this man's money into the account that's been exclusively set up in his name. We were able to revoke his power of attorney, which was wifey. We were able to change who his beneficiary was, of survivorship, right? And we did all these things, and you know what it was? It was me on the line telling them what was going on, and him going, yeah, this is my name, this is my date of birth, and yes, you go ahead and you do those things. Would he have had the wherewithal to do those things on his own? No, definitely not. Was he capable? Maybe not, but there's a presumption in law that he's capable. And so you know what, you take that, and to the benefit of that man, you do some damage control, right? It's a matter of pushing the envelope. It's a matter of creativity and persistence to change the direction of things, to stop the bleeding, in essence, right? So just an example for you. Not everyone might agree with, however, moving right along. So the capable victim section of the tool is not, it's not it's in point form, but it's not numbered, because there's no set definitive way. This was something that we discussed when we were developing it the second time around, is we don't want to number in what order these things are done, because, some things will be done, not everything. These are just points to consider. So the first one being to visit the victim and obtain financial particulars. Once authorized by the victim, look for alternative sources of information. And so, again, the ideal situation is really to get there in person, because we're better able to control the environment. Something that we've also noticed a lot is there's that bullying or there's that intimidation that's happening, especially when the caregiver is living in the home. What's the point in calling? Someone's breathing down the neck, someone's controlling how things are going to be run. And so we need to get in there, and we need to, and this is, again, it's a police officer's guide, but again, for, anybody on the front line, to get in there and establish that rapport. And it's really critical for a successful intervention and for our next steps if there's a subsequent investigation. So the second point, I'll number them myself just to stay on track, is to obtain from the victim a completed consent form for the release of their financial records. And again, this is assuming that this person is capable, right? So, and also obtain a copy of the power of attorney for property if you can. Oftentimes it's disappeared. So a Word document should suffice. That's what we do in our jurisdiction, is it's just drawing up a blank paper and, dating it at the City of Ottawa and basically pointing out, like, I, so-and-so, born whatever date, do hereby give Toronto Dominion Bank the authorization or my permission to disclose my banking information to the Ottawa Police pursuant to an investigation that's being done under, case number or whatever our report number might be, which just kind of, legitimizes it that much more, or just gives it like a bit of a reference point. And they sign off, and, oftentimes just faxing that over to the banking institution is enough. It's adequate that they'll, get the ball rolling and share information with us, because people are really hinging on just having the consent in order to move forward or in order to share information. So the third piece is let the victim know that they have the right to revoke the power of attorney if they wish, and how they can go about doing so. It goes on to say here, revocations and, if appropriate, new powers of attorney should be put in writing and provided to those relevant to the victim's financial circumstances. Refer the older adult to your victim service program and or give the older adult numbers for your province or territory from the list. And so there's a website here that will basically enumerate all the different supports that we've been able to kind of hang our hats on to post on the NICE, it's not the NICE, it's the government website. Okay, and this is the same idea too for revoking. It's a Word document, that's dated. It's as simple as that. It's just basically indicating, that dated this day, I hereby do revoke all pre-existing power of attorney documents that may be out and about, being waved in other people's faces. I hereby revoke this power of attorney, and it's signed and it's witnessed, ideally by two people, and that, we'll fax off to the banks to just kind of, again, put a plug in it, just stop it, just freeze things. And, again, we do encourage, due diligence, obviously. So the fourth point, and also the sixth and seventh point, just kind of speaks to the same thing, more or less, is calling the financial institution immediately. I just kind of covered off on that. You speak to the officer of the bank, advise them that you're doing this investigation. You confirm, that the information you've been given thus far is accurate. And yeah, you'll have to just disregard some of this stuff here because we've amended our tool, and I've not amended the slide to go with the tool. But really, a production order, we'll talk about later, is not necessary for a victim's banking details if you're getting consent. But to get a suspect's account information, that's a different story. So, and we still reference Lilico in here, Allison. You know what? You just changed these for this conference, right?
Yeah.
So the Lilico references, it's still in here?
No, it's under incapable.
It's under incapable. Okay. All right. Well, we'll talk about that now, just to stay in my order here. With Lilico, it's an interesting. It's an interesting case in that it's with respect to, it was a 1994 Ontario Court of Justice case. And it's interesting in the sense that it's actually two police officers who are the main players in this piece of case law. It's, well, one's obviously a bad guy and the other guy's the victim. And they embark on what the victim thinks is a business venture. And bad guy says, okay, yeah, here, give me all your money. And we're going to embark on this business venture, and then he pretty much, doesn't come through. And so, long story short, he makes a complaint, and it's being investigated by the police. And so what the police do is they go to the bank, and they're looking for tombstone information. And so I guess what I should say, too, is that the police can't just go to a random bank and start guessing and say, is there an account here? Is there an account here? It's like a fishing expedition. And so this kind of gave us a bit of a foothold on how we might, or how we're justified in getting tombstone information. So I'm just going to read a little bit of this so that I don't get off track here. The tombstone information was to confirm that the suspect did indeed have an account at that institution. This is what the police officer investigating wanted to know. So yes, the bank confirmed that there was an account there in the bad guy's name, and that there was a big check that was deposited to the account. They also got that information, and that there was an increase in activity on the account following that big check going in there. So the officer doing the investigation knew that much, and on the strength of that, then did a production order. Because it's a lot of work to prepare a production order. It's quite a bit of paperwork. And so they then produce the production order to the bank and look for, the nooks and crannies of exactly what happened. And so what happens is at trial, the defense lawyer made a charter application saying that his client's Section 8 charter rights had been violated, and that's the right to unreasonable search and seizure, right against it. So they argued that the officer doing the investigation should have never been entitled to that preliminary information, and that because he got that preliminary information illegally, so they say, that everything that followed suit would not be admissible either. But the conundrum is that without all of those details, you don't have a case, because it's really reliant upon all the financial documentation to actually go ahead with a charge. And so there would never have been any kind of a conviction. So it was a bit of an issue. So what happened was in His Honor's findings in the Lilico matter, the justice was Justice McCombs. He states as follows. He says, not all commercial information is protected by Section 8 of the Charter. And in order for constitutional protection to be extended, the information seized must be of a, quote, personal and confidential nature. And we're talking about numbers. We're not talking about more detail or more personal detail. So Section 8 of the Charter should seek to protect a, quote, biographical core of personal information. This would include information which tends to reveal intimate details of the lifestyle and personal choices of an individual. So he goes on to say, a balance must be struck between the customer's right to confidentiality and the public's right to effective law enforcement. And he says, in my opinion, disclosure of only the most general information by confirming only that a particular check was deposited into the customer's account and that there was subsequent activity in the account does not threaten the biographical core of personal information, which is inherent in the remaining of the phrase private and confidential. So he finishes by saying, I therefore conclude that in this case the police obtained the information lawfully and the disclosure made by the bank employee did not constitute a breach of Section 8. So it was a little win, it was a little victory. And so on the strength of that, we, in doing the education piece to the officers who are going to use this, are trying to make it abundantly clear that, you can cite R versus Lilico as your authority to be asking the bank, what, I need this information up front. So that's kind of something we try to weave in, but it's way too much detail to throw into this tool. It's already got too many words on it. So moving right along. So the fifth point says, take a formal statement from the victim, obtain a KGB video statement. KGB, that's case law as well, has nothing to do with Russian mafia and all that good stuff. So a KGB statement, an audio statement, or a written statement. It says, be mobile, take a camera to the victim when resources allow, right? And that's what we do in our jurisdiction, is we've got the tripod and the camcorder and the Bible, and we go out and we do like a makeshift swearing of information, which is like a KGB. And so you're trying to seize the information up front. And secure it as best as you can. So sort of like a courtroom, put your hand on the Bible and swear. It's a soft KGB. It's not in a courtroom, but it's something that we try, again, pushing the envelope and trying to make that work. But again, something that is put to the officers who are investigating and laying charges is to flag the file for commissioned evidence, making a request to the Crown to consider commissioned evidence, which was, again, something that came out of another piece of case law, which is Kellowan. And in a nutshell, Kellowan, not to go into too much detail, but that was an Ontario Court of Appeal decision in February of 2005. And just to very cursory tell you what that was, it was physical assaults that came out from an investigation into a retirement home in the Toronto area, and I think it was the administrator of the home was the one he was the culprit, and he had assaulted a number of people residing there. And so the police went in and tried to do their, cross the T's, dot the I's, and seize as much of what they could at the time, like in terms of videotaping the statements from the victims. And of course, as luck would have it, fast forward, we finally get to court, and the victims are no longer with us to be able to testify. And this is another thing that I'm finding more and more, too, is with defense, is they catch wind of, oh, this is an old victim? Yeah, you know what? We're going to kick this around. We're going to use stall tactics. We're going to adjourn. We're going to use back doors to try to really slow this down, because one of two things might happen. They're hoping the victim will be completely, or more diminished and not able to remember, not able to really convey what's going on in terms of providing a statement in the courts, or they won't even be with us anymore. And I had one victim call me in distress and say, my daughter just called and said, quote, we're going to kick this around until you either don't remember it or you're dead. Like, you're never going to see justice. You're never going to be in court. We're not going to let you have that day. So, ooh, that was cold. So what ends up happening is they're not around to provide their statements, and so the Crown enters the videotaped statements, and on the strength of the statements, or part and parcel of everything else in the trial, this guy's convicted. But defense argues that it wasn't fair because he wasn't allowed to cross-examine these victims, right? Because that's generally what happens. Tell us your story, let the defense try to poke as many holes into as they can, and then Crown comes back and tries to, unruffle the feathers again and just put it back together again. And so what happens is defense is saying, this statement wasn't entirely reliable. I would have had all kinds of issues to make in this, and I haven't been given the opportunity. And so on the strength of that, more or less, the conviction's overturned. But what the judge also says, though, is that there is a provision in the criminal code that puts an onus on the Crown to apply for what we call commissioned evidence. And that is, in essence, when it's foreseeable that somebody may not be with us, right? So you're dealing with an older victim, it should be standard. When you're processing an elder abuse file, it should be standard that you make this application for commissioned evidence. And really what it is it's a request. Because another loophole that we've experienced is that, which is a good thing, is that the commissioned evidence doesn't even have to come to pass. This whole application doesn't even have to come to fruition. Just the mere fact that the Crown made the application is all the Crown needs to do, and so we're covered. But commissioned evidence is this. It's and I've done this, is you go into a victim's home, because, generally speaking, that's the ideal. You don't want to be dragging them into a police station. Is you go into their home, tripod, camcorder, Bible, that whole thing, with the Crown, with the defense, and with an adjudicator. And you get that information up front. You secure it, you get it cross-examined, appease everybody, you get it cross-examined, you get it re-examined, and then you package it, and you basically stuff it away on a shelf. And so whenever we finally get to court, And at whatever juncture within the trial setting, that piece of evidence, that statement is taken off the shelf and it's inserted in the trial wherever it needs to be inserted. And so it's really salvaged. And so that's something else that, we can't endorse enough, really, for these types of investigations that move forward to the courts. So 6 and 7 we already pretty much spoke to. That's taking the consent form to the financial institution and identify other sources of obtaining evidence. So going on to laying charges. Is this where we are? Yeah. So basically laying or recommending the laying of charges. In some jurisdictions it's not the police who lay it, it's the Crown who has to be sold on the idea of laying it. So that's why that's in there. And then really critical too is maybe getting the bad guy to consider resigning as the power of attorney. And I have another little case to illustrate to that too. And it was great because you know what? It didn't even result in charges, actually. This was something I was able to do in lieu of charges. I had a nursing home who called and said, look, we have a lady here who's in arrears to the tune of $40,000. And pardon me, because it's a nursing home, she's impecunious, and so it's not like a landlord-tenant situation where they kick her to the curb. They have to keep absorbing this loss month after month after month, and so they call the police because they don't know what to do anymore. And as much as the police will sometimes say, we're not in the business of collecting debts for people, this was a theft by power of attorney case. And so what happened was, when I looked into it further, the son was, relatively respectable guy. I mean, he was stealing, obviously, but I mean, he had a job, he had a family, he never was in any trouble with the police before. It was that self-entitlement thing, right? And so he was just using up everything, taking advantage of the fact that his mother would never be kicked out of where she was, and so just kind of, riding high on the hog and living off of her pensions. And so what happened was, I paid a visit to this guy and let him know that this is criminal. You could be charged for something like this, and he didn't like the idea of that. I mean, that's it really was, and it was a matter of and I don't look threatening, I don't think, I mean, honestly, but it was a matter of just making him understand what was in jeopardy here. Like, I work day shift, so you'll likely get a visit from somebody at the state or at your workplace. And it won't look like me. I'm going to have to send a couple of patrol guys out there with a car, and you'll be arrested because you committed a crime, and this will happen, and this will happen, and so call it threats and inducements, whatever. It's creativity. It's conveying to this guy what's at stake, right? No, but honestly, right? It's what's at stake here, and there is no fixed, perfect template on how to do things. You really do need to kind of try to think outside the box and not abuse authority, but just find some ways to get the message across. And so this guy was a quick study, and he just said, you know what, give me a day. And he went to his bank, he collapsed his RSPs, he collapsed his wife's RSPs, and he showed up the next day with a draft in hand, and together we made our way to the home. He paid off the debt in full, but what's more than that, he was asked nicely to call the pension sources and arrange, as the power of attorney who could speak for his mother at the time, to redirect the pension sources into an account that was set up for his mom at the home, because that's where the money needed to go. And as soon as he did that, it was also suggested very gently that he resign as power of attorney, so that it would minimize any more temptation to have this happen again. And so he handed it over very happily. He was happy that he was never charged. Nobody had to go through the justice system. He didn't have to fork out, probably half that much money on a defense lawyer anyway. And, it expedited things. It solved the problem. Do I think he's going to go out and do that to somebody else? No, he's not a recidivist. He's not like some serial, thief. He was just taking advantage of a situation that was, just too irresistible. And so we fixed it, right? So anyway, all of that to say, thank you. Yeah, so anyway, so going to the incapable section of the tool, basically obtaining the victim's financial particulars, look for alternative sources to gather the victim's financial particulars, right? Obtain a copy of the POA for property if you can. Consideration should also be given to enlisting the aid of other agencies who are going to be able to provide support to the victim. 'Cause again, this is multi-pronged, right? Like we're dealing with the criminal aspect of it, but in a lot of cases, it might be the caregiver who's the culprit, and if we have to remove them, clearly, you'd hope that the officers responding would be cognizant of that. Like you can't just up and take everything away, all the supports away. So it's here for that. What else here? Yeah, so again, looking for tombstone information on the victim, and now they can't give you the consent. So you got to, again, try to find ways to get that information. And the bank, again, needs to be reminded of their due diligence in protecting their clients' interests. And PIPEDA, the Personal Information Protection and Electronic Documents Act, which is a federal piece of legislation, can certainly be used here to draw that information out. And I'm going to speak to that in the next slide, or two. Anyway, so notice to the public guardian and trustee are equivalent, again, because the victim is incapable. And a sworn videotape statement. Sorry, so I'm booting along here. Let's just skip to the third one, which is evidence of possible incapacity coupled with financial risk, basically serious adverse effects could be associated, suggests notification to the public guardian and trustee or curator in some jurisdictions, as they may have special asset freezing and or investigative powers. And I understand here in this province, there's quite a lot of authority that can be wielded by the public guardian office, right? So yeah, so for the officers responding to be mindful of pulling them in as well, or to the investigator. And the sworn videotape statements, yes, sorry. Take a formal statement from the victim, and don't let the victim's level of incapacity prevent you from obtaining that statement. It says use your judgment. And really, even if there's little or no probative value in what is being said, just the mere exposure of that victim to the courts could really drive the message home. And, I can't say that enough, because, I've had other investigators who go, well, what's the point? We're not going to get anything. It's like, I know, exactly. And that is why it's really critical to show that judge who might not get it. This is why this person's a victim. Look it. They cannot fend for themselves. They cannot articulate an argument. That's why it happened to them. And so even if it's for that, nothing probative here, but just, exposing them, I think that can really have an impact. So joint power of attorney can provide consent or provide information if you're still trying to find some financial documentation. If there's a joint power of attorney, and all this is exclusively in a case where you've got joint power of attorney and somebody's done something bad, and there's another person who's maybe the white sheep that will be able to give you access, it's something to entertain as the investigator looking for the information. So, but if it's not possible to locate them, it's not possible to get that consent, again, PIPEDA might come in handy. But if they are resistant and, maybe also questionable in terms of, where they tie into that, then that would be a production order. Because it would be a shame to see, an investigation go south just because we're trying to get, information without proper channels. Sometimes we do need to rely on search warrants and production orders to draw that, to get that information in our hands. So, okay, so PIPEDA. This is, as I said, federal legislation, and as such, it can be drawn, or likely be drawn upon in all provinces or territories across the country. However, one would have to conduct more comprehensive research in order to acquire a better determination of how it might intersect with existing legislation in your own respective province, right? And this is something that, has to be said in every jurisdiction we go to with this, because it's just, the law is far too vast to just be able to blanket it and say, you can always use this. But I know I can speak from my own territory, and from an investigative standpoint, this legislation relates largely to commercial information, and we've referred a variety of organizations to its provisions, such as banks, other creditors, real estate companies, car dealerships, home furnishing stores. Like it's commercial stuff. I said car dealerships, and also federal and private pension sources would tie in with this. Would be would be able to rely on this stuff. So what did I do here? I'm sorry. So let's read it. So Section 7 of the Act basically says that for the purpose of Clause 4.3 of Schedule 1, I will show you what that is. And despite the note that accompanies that clause, it says an organization may disclose personal information without the knowledge or consent of the individual only if the disclosure is made to a government institution or part of a government institution. So basically what I'm saying here in a nutshell is to the police, right? So an organization may disclose personal information without knowledge or consent of that person to the police, all right, for the information, that has made a request for the information and identified its lawful authority. That I will speak to in a minute as well. So identified its lawful authority to obtain it and indicated that the disclosure is requested for the purpose of enforcing any law of Canada. So basically, it's me calling the bank and saying, look, I'm doing an investigation into whatever, and I need this information. So you, the bank, may share this with me pursuant to Section 7. Okay, so, or it's even for gathering intelligence. So I may not even have a charge that I know that I'm going to be able to lay, but just for the purpose of preliminarily getting information or intelligence up front, I can also be making this request, and they, the banks, or whomever, commercial institution, may share that information with me. And an organization, by definition, within the Act, again, means an association, a partnership, a person, and a trade union, and that includes, again, through checking with the appropriate legal channels, federal undertakings such as banks, crown corporations, etc. So here is the schedule, and it says in certain circumstances, personal information can be collected, used, or disclosed without knowledge or consent of the individual. For example, legal, medical, or security reasons may make it impossible or impractical to seek consent. When information is being collected for the detection and prevention of fraud or for law enforcement, seeking the consent of the individual might defeat the purpose of collecting the information. Seeking consent may be impossible or inappropriate when the individual is a minor, seriously ill, or mentally incapacitated. Isn't that a lot of common sense built into a piece of legislation? I mean, I always like clicking my heels when I came across this stuff. So this is another piece that's even better because it enables the sharing of information by the organization without prompting by the police. And because this is the issue, right? Like, the proverbial you-know-what has had to hit the fan for me to know, for me to then run to the bank and say, okay, I'm investigating something. What about the banks on the front end seeing something and saying, ooh, what can I do with this, right? I might lose my job. I might get, fined. My employer might get fined. All that fear-mongering stuff, which is also part of this same piece of legislation that will spell out, how you're not allowed to say stuff. This is the enabling aspect of it. So basically it says here, again without knowledge or consent, there's disclosure that's permitted. And I'll just read what's highlighted here or what's in bold. It says an organization may disclose personal information without knowledge or consent if made on the initiative of the organization to an investigative body, government institution, or blah, 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 part of a government institution, and the organization has reasonable grounds to believe that the information relates to a breach of an agreement or contravention of the law. So basically a theft, right? That has been, is being, or is about to be committed. So there's even like a proactive portion that's built into this. You see that? Is about to be committed. So it's not even a reactionary, the money's all gone, what do we do now? But wow, you know what? I smell a rat. Maybe I should call. It's right there. It's the law, right? And it's federal. It encompasses the entire country. But again, I have to say, you need to check with your legal advisor. You really do need to check with your legal advisor within your respective organization to see how, if there's policies that might trump that, because this is a permission. It's not an obligation. It doesn't say you may, you must, and you shall. It says you may. It's discretionary. So, and this is an immunity that's built into the Act. And it says no criminal or civil proceedings lie against the commissioner or against any person acting on behalf or under the direction of the commissioner. That means anyone acting on Section 7 that we just touched on. So anyone who has taken an action in following what we just talked about in Section 7 of this Act, okay, that no criminal or civil proceedings would lie against them for anything done, reported, or said in good faith and reasonably Sorry, it doesn't say reasonably here. That's another legislation. Anything done, reported, or said in good faith and as a result of the performance or exercise of their duties, right? So, right. And then there's more, again, and this is a bill that has not been enacted yet, but this bill, C-29, oh, sorry, I don't know if we'll have time for that, but Bill C-29 basically speaks to the personal information. It speaks to this legislation, and it says this bill specifies that lawful authority is not limited to a subpoena or warrant, because I had said earlier when the police call and they state their lawful authority, that's been contentious, because some defense lawyers have said, well, lawful authority means you have to do paperwork, you have to do a production order or a warrant. What this bill is basically stating is that it's not limited to that. Or to rules of court related to the production of records. This authority appears to be a more general authority that is left undefined. It says Bill C-29 also specifies that the organization who is disclosing the information to the authorities without consent is under no legal obligation to verify that it possesses the necessary lawful authority. So it's not the bank's responsibility to try to find out where is your authority to be asking me for this. That's what this bill is implying. Bill C-29 would allow disclosure without consent to organizations in general, presumably including other companies. So what is being proposed here is that this is going to branch away not only from banks being able to share information with the police, but banks being able to share information with the other bank. You know, one organization seeing something, and then, because this is the thing too, is you get a bad apple and they move around from place to place. They wreak havoc because they do something bad in one place, and then the heat gets so hot in the kitchen they bugger off, and then they go to the next place, and the next place calls the first place and says, what can you tell me about this person? And they go, we can't say anything because we're going to lose our job or we're going to get sued or whatever. And what this is saying is we're enabling you to say, you know what, don't hire that person. That's not a good idea because, whatever. So, again, within reason, but this is just, it's promising. Is all I can say. So, how much time do we have? Oh, really? Awesome. Motor mouth. I'm going fast. Okay, so I'll just give you a case study, something that I worked on not that long ago. That's a theft by power of attorney case. We'll call him Mr. W. Mr. W was only 60, and we actually work with, our mandate is 65 and older. But he was sort of like a borderline because we weren't sure if, he'd not been diagnosed with anything, but he was described as simple. Like when I was starting to sift through it a little bit and talking to people who knew him better, he was very gullible and definitely vulnerable. So he lived independently in the community, and it was interesting too because he was from a European country. He had lived with his mom and dad pretty much all of his life. He had a brother who was in Ottawa, and the brother was, a very well-to-do. He was a very hard-working immigrant. He was a bit of an entrepreneur. He owned a little, a deli kind of place, and he had a number of properties, little rental units and stuff. And so what happens is W is living with mom and dad dies, and they were quite well-to-do as well. Left this huge inheritance to W, and dad dies, and so mom calls the brother, the capable brother, and says, I can't cope. I can't do this now. You have to take him off my hands. And so he sends a plane ticket, and W comes over to Ottawa, and he gives him a job in his deli, and he sets him up in one of the units that he has in one of the apartment buildings. And wouldn't you know it, W wins the lottery. He wins, I know, good for him, eh? So he wins, but it's only like $250,000. He wins $250,000. I know, nothing to sneeze at. I wouldn't mind that. But so he wins $250,000, and the brother, being very prudent and good with money, says, you know what? No, we're going to buy you a property. We're going to buy you a duplex. So you have somewhere to live, and you're also going to generate an income from having some tenants. And he was very, shrewd and savvy, and so he set up his brother, and so he didn't have to work in the deli anymore, but he had lots of time on his hands, and he liked his beer, and so he would go down to the neighborhood pub, and he'd have, his several beer a day, and he'd talk to anyone and tell anyone about everything, and this big inheritance that he was about to get. And so, all the vultures came out, right? And he'd gone through a series of vultures, actually. It's a pretty sordid, complicated mess that I don't have time for, but anyway. So this one particular person befriends him, we'll call her C, And he's a bit enamored with her, and so he meets up with her in June of '09, and within 3 weeks, she becomes his power of attorney, right, for property. And shortly after that, the beneficiary of 50% of his estate. So she managed to change the will, case in point, as I mentioned earlier. So anyway, so he has these tenants, and he has a good rapport with the tenants that live on the main floor. And, you know, they kind of feel bad for him. They're good, benevolent, kind people, and considerably younger. But, you know, they invite him in for dinner now and then. And the girl, actually, of that couple, she's got parents that live around the corner. And so those parents actually kind of keep an eye on him, too, just to make sure. And they're just kind, good-hearted people. So anyway, within days of taking over as power of attorney, she's seen. She tells W that she's going to convert his home to a bed and breakfast, and the home is actually situated in a good, part of Ottawa. I mean, it certainly wouldn't be worth anything here, but your real estate's crazy. But anyway, so he's got a nice home that has a lot of potential, and so she sees dollar signs and says she's going to convert it. And so with the newfound power of attorney, she starts making the calls and getting ready to make this big conversion. And he doesn't want it. Like, he's saying, I'm not interested, I don't want this. And, you know, he's lucid. He's just vulnerable or gullible. So anyway, what happens is the tenants are noticing things, you know, like she's disingenuous. She's pretty easy to read, although he's not seeing it. But, you know, she's yelling at him. He used to go to the little corner store like every day. He had lots of time, as I said, on his hands, so he'd just sort of go in and bide his time in the mornings. And whenever she would pull up, you know, he would scramble home because he wasn't allowed to leave the house. She bought cell phones with his money and instructed him that if the call display didn't show her number, he wasn't allowed to answer it. So she really put the controls on him. She really isolated him as best as she could. And so in July, a month after she takes over as power of attorney, she serves an eviction notice on these tenants who had been there for 3 years. And she's also we ended up canvassing neighbors later on, and we were told that, you know, she was pretty much strutting up and down the street with these papers in her hand, explaining like why all the trucks and the backhoe or whatever was on the property. she's power of attorney, and she's doing all these wonderful things for this poor guy. So and really this was. The other thing, too, is she made a lot of calls to the police complaining about the tenants. And she was building a case for herself. She was very, very crafty. We ended up finding out that she had, there was another gentleman who was in his 80s that she was also taking advantage of at the same time. So she was trying to, like, juggle these two guys in the air and just creating witnesses everywhere she went, like beating people to the punch, making complaints and building cases for herself so that she would, smell like a rose. So anyway, so she'd also said that she'd brought him to see a doctor and that the doctor had assessed him as being incapable. Now, of course, nobody, that paperwork never materialized. We were never able to see a doctor's report that said that. And then when we asked Mr. W, he did acknowledge that he'd been taken to a doctor, but he didn't know where it was. He didn't remember the doctor's name, but he did say, I asked her many times to show me the paper, and she didn't. So, sound familiar? I mean, that's what happens, right? So the tenants protested their eviction. They appealed it. They went to the Tenant Protection Tribunal, and nobody even asked Mr. W what he wanted. It was C fighting against the tenants. C won, because, again, she's waving the power of attorney documents in everybody's face. She's the landlord for all intents and purposes now. She's calling the shots. So anyway, out they had to go. And that resulted in a loss of $1,000 a month revenue that Mr. W was pulling in from the rent. And within days of the tenants leaving, the destruction crew came in, and it was quite a scene. The front and back steps leading into the house were removed, and there was probably about a 3-foot drop from the front door out, and at the back door was, you could walk out, but there was like a cement wall that was probably about 5 feet high that had cement steps at one point coming down from the ground, and so it was like a major fire trap. Like what would happen if you went? He'd have to clamber up this 5 foot high or more cement wall. So anyway, the steps are ripped out first. Don't know why. Walls are torn down. Floors are pulled up. Nothing is ever restored ever. Building permits weren't properly attained. Contractors weren't being paid. It was a mess. She was spending the money everywhere else. And Mr. W ended up in this tiny little makeshift room in the basement that one of the contractors, who actually had a heart for this guy, thought that he should do before they move out. Like, we're leaving. I know that there's nothing, it's not a livable place, but I'm going to make this like a little closet for you in the basement, and you can live here. And so it ended up in really poor condition. The city inspector caught wind of it and basically condemned it and said, you can't live here anymore. So we came to know about it because when he got kicked out, he went around the corner to that young girl's parents who were still there, and they took him in and they called the police. Otherwise, I wouldn't even known about it. So this is, the pictures never do it justice, but here you see the front door, and there's like a pile of dirt in the front yard here. I don't even know why or where that came from, but there's a good 3 foot drop down to the ground from the front door. And this is the look of the inside of his house with the wires hanging and the insulation all ripped out, and I don't know if those are 2x4s. I always forget what those are called, these joists or whatever. And then here at the bottom is the cement wall I was talking about, and you can see where the steps once were. So that's basically what the house looked like when we happened upon it. And this is Mr. W, and this is his makeshift residence. And you can see there's probably about a 1-inch clearing from the top of his head to these pipes and bits of wood and stuff. So clearly I'm not a contractor. I don't know all the terminology, but it was quite sad. Very sad. So, where are we? So we attended the home. We brought him to the police station. He was very happy to talk with us. And he had a moderate speech impediment, I noticed, but he appeared quite lucid, but very much controlled by her, very much. And by that I mean his cell phone rang 18 times while I was having my interview with him. I talked to him for about 2 hours. The phone rang 18 times, and it was so sad because we would be talking, and then the cell phone would ring. And let's say this was the cell phone here. He would like tense up and kind of cant his body away from the phone and hold himself, and he'd just be looking at the phone and looking at me and not knowing what to do. And so I was instructing him and saying, okay, say this, like pick up the phone and just say that you don't want her to call you anymore, because then I've got a criminal harassing telephone calls charge. But he has to say stop calling me, and then I've got her for a harassing telephone call. But he couldn't even muster that. He'd get on the phone, and because of the speech impediment, but also because of that dynamic, and she was like just prattling on, and he'd be like, yeah. And so I take the phone and I just listen quietly, and it was sickening. Like, you know that I'm the only one who cares about you. You know I'm doing everything for you good. Don't you know that? You know that. Tell me you know that. And no, everybody else is out to get you. And it was just incessant. It was sad. So anyway, the interview and subsequent investigation revealed a number of items, and that being that between September and December, she'd gone through $135,000 of his money. And where else am I here? Sorry. Largely by means of his of cash withdrawals. And she'd taken his bank card a long time earlier. Almost $64,000 was apparently wages, building materials, and repairs to her own vehicle. He'd racked up cell phone bills. They were, about $300 to $400 a month for his cell phone. And she was the only one that was calling him. Like, he wasn't allowed to answer the phone for anything else. So anyway, that's a lot of phone calls, I guess, in my estimation. Oh, and interestingly, too, like the 18 calls that came through, I asked him, do you want to leave this cell phone with me? Like, you don't have to have this cell phone anymore, eh? Like, he was ecstatic. He couldn't believe that was an option. He couldn't believe that I could actually take that cell phone away from him and he'd never have to hear it ring again. Like, it was that, you know what I mean? It was just, yeah. So, yeah, and then the revocation of power of attorney, I can do that? Absolutely. We're going to do that right now. Let's do that right now. I got a partner here. She's going to witness it. We're going to revoke that. Like, he didn't know those things. And so, you know, oh, and the other thing, too, is the phone rang 12 more times as I was drawing up the paperwork. So like 30 times she called in about a 2.5-hour range. Just unbelievable. I know, I'm almost done. Oh, was it? Okay. All right, so the outcome was she was arrested. She was charged with criminal harassment, harassing phone calls. I managed to get that one in there. Mischief, theft by power of attorney, misappropriation of money held under direction, fraudulent concealment of property, and theft by person required to account. You know, intricate you know, creative ways of drawing on all the different provisions. And there were several conditions that were laid again on her, which were basically no communication, obviously, with Mr. W anymore, and not to try to get power of attorney for anybody else. And so the power of attorney was revoked, the cell phone canceled, and unfortunately the property damage was too costly to repair. So, yeah, so, and this is still before the courts, so he's still living with the friends around the corner. And we tried to pull the brother back in and get him to sort of loosen up some purse strings so that, you know, we could sort of restore some things, but that was a whole other mess. So yeah, so that's essentially it. And I don't think there's a lot of police who do investigations in the room to really have to go into that. So basically, bottom line, best practices is to ask for consent, and if they're at risk and resistant and also incapable, to consult with legal representation to ascertain what legislation applies in order to go forward. And then, of course, Crime Stoppers, right? Some people are really in a position where they don't feel like they can come forward, that there's too much jeopardy in terms of who they work for and that sort of thing, and that's why that's always something that follows the presentation is to be aware of Crime Stoppers. It's anonymous, and it doesn't pull in the tipster at all. So anyway, that's my presentation. I guess there's no time for questions. Sorry. Okay. Thanks for your attention. Okay.
So the power of attorney tool is up in piloting version. So if people have thoughts about it, comments, please let me know. And thanks a lot.
That was amazing. I think that Christina and Bernie would make an incredible pair. Really great. It's very good. Thank you very much for... you know, we've had very few people leave, which is a really good sign that this has been something that you've really gotten a lot out of. We've been running around the province. We've done 9 knowledge exchanges, and sometimes we get them to stay, and often by 3 o'clock in the afternoon, they're gone. So this is very good. So I'd like to thank all of you for being with us today. I was talking to somebody just... earlier about the changes that we're experiencing in these kinds of events with the internet. We can now provide you with a ton of material which you can't possibly all absorb, but you have the links, you know where to get it, you know that the material exists, which is really important information. And you don't have to worry about remembering it all because it's going to be hard to find again. So I think that we've really done a great job. And thank you, Kathleen, especially, and your leadership in this. It's been really good. And Allison, for your support and bringing us such interesting material. So we have one more thing to do. In your folders, there is an evaluation form. There are 2 evaluation forms. However... So the top one is from NICE, has the NICE Elder Abuse Team, and you don't have to fill that one out. You can put that away. You don't have to fill that one out because it wasn't the right one for this event. So put it in the recycling. But we do want you to, before you leave, to fill out this one, the spotlight on financial abuse feedback form. So if you would fill it out before you get up, you can leave it on your table or take it down to Harola. Probably leave it with Harola at the back. She's waving. We'd really like you to do that before you leave, and we can catch a little bit of sunshine. For the BCA CRN board and mentors, it would be probably a good idea if you'd come up here so we can give you some last-minute instructions about the next step. We have an annual general meeting this afternoon at 5:30, so we need to know how to get to that. So Thank you very much, everyone. And I hope that we can do something equally stimulating for World Elder Abuse Awareness Day next year. Thank you.